Many are suggesting it was the president's own legal team, by the way, who leaked those nearly 4 dozen questions. If so, what was their motive? Let's talk about it with our legal eagles. Harry Litman, a former U.S. attorney and DOJ official, and constitutional law attorney Robert Barnes. Welcome to both of you.
Glad to be here.
Okay, so the president, Ed mentioned this, had a tweet saying it's so disgraceful that these questions about the Russian witch hunt were leaked to the media. But a lot of people think it's his team, either current or former, who leaked them. Howard, I'll start with you. What do you think?
You want to start with me, Shannon?
Yep.
Yeah, I don't think it was Mueller. I mean, Mueller has been largely touted as the most leak-free operation in Washington history. And it stands to reason that somebody on Trump's team, because that's where the leaks have been coming from in general, you want to ask, why are they doing it? And I think probably to try to set up an argument that Mueller is aiming very broadly, that he's overreaching, and to try to pave the way for not cooperating fully. That would be my sense. No evidence that that Mueller has leaked a single thing since the probe started.
Yeah, and Robert, you know, a lot of people think that it was the president's own legal team, either past or present, who leaked these questions because what we're told is that he was, quote, furious or very upset after hearing these questions and what was out there and seeing what was on the list of questions. Is this his own team warning him as he continues to say he wants to sit down with the special counsel team and talk to them? Robert, is this their way of warning him by saying, by the way, just get a look at what you're going to have to answer? And these aren't just topics. I mean, these aren't just questions. These are probably just the topics. Probably a lot more questions.
Well, it's definitely possible. I would note that Manafort's team today or yesterday filed a motion with the court noting the long history of Mueller leaking in this case, so they clearly have a different interpretation of Mueller's history of leaking. But I concur that, in fact, what these questions do is they embarrass Mueller because they expose the complete lack of evidence of any criminal collusion involving the campaign and President Trump. 95% of the questions have nothing to do with the campaign at all. Most of them have to do with things that involve attorney-client or executive privilege. And it's embarrassing because it's the contrast between how Hillary was treated by James Comey, Bob Mueller's buddy and longtime pal and protege, where she was given the opportunity. Her interview was done after the clearance letter had already been done, the closing letter had already been done, immunity had been given out to all of her key people, and her questions were not even under oath with her counsel present. And yet here you have Bob Mueller threatening to issue a grand jury subpoena for the first time in history to a president of the United States. So the contrast, the exposure of these questions definitely helps the president. So it wouldn't surprise me that someone close to the president did do so.
Okay, you mentioned the subpoena report from the Washington Post this tonight. In a tense meeting in early March with the special counsel, President Trump's lawyers insisted he had no obligation to talk with federal investigators probing Russia's interference in the 2016 presidential campaign. But special counsel Robert S. Mueller III responded that he had another option if Trump declined. He could issue a subpoena for the president to appear before a grand jury, according to 4 people familiar with the encounter. Want to get reaction from both of you. Harry, we'll start with you.
Sure. I don't doubt it at all, because eventually he's going to insist on some answer of questions under oath, and if Trump absolutely refuses, that's his path. I think Robert's wrong, and a subpoena has issued before for the president's testimony. That was in the Clinton case. Starr issued a subpoena. Clinton voluntarily complied with it, but it had been issued. But that's just sort of, the straightforward tool that he has. Most people think it will be easily honored. I tend to think it's that the Trump team will have some more arguments than others. I want to say quickly, Roberts has sounded this refrain again, no evidence of collusion, and that just strikes me as very puzzling, because we know that Mueller, by his charge, has not come forward with his case yet. We have much reason to believe he's gathered all kinds of evidence, has secured many convictions.
All right, we gotta wrap
go
it.
ahead.
Okay, Robert, quick final word to you on that.
Sure. The reality is there's no evidence of collusion by the nature of the questions, which don't point to any evidence even relating to the campaign. Independent of that, there are serious constitutional questions with any grand jury subpoena. The Ken Starr subpoena was withdrawn, and so it didn't end up getting fully contested and go up through the court system. And there are serious, both scholars on the left and the right agree, there are serious constitutional problems and questions about any use of criminal process against the President of the United States, particularly from a rogue prosecutor like Mueller.
Oh, we got to leave it there, Harry. I know you'd love to respond.
Harry
and Robert, thank you both. Come back soon.
Thanks, Shannon. Thank you, Bob.